Employee relations is simply the relationship that an employee has with the organization. Now, for this relationship to be formed, the employee has to deal with certain areas. We need to know stakeholders, we need to know policies and procedures, we need to know our contractual commitments. All those sorts of things form part of employee relations. Let's take a look at what is a stakeholder. Any person, group, and/or organization that has interest or concern in an organization or task, project, and/or activity, that is a stakeholder. We get internal and external stakeholders. Examples of internal stakeholders: employees, your colleagues, owners of an organization, managers. External, we have suppliers, the society, government, creditors, shareholders, customers. So all those people that have an interest in your organization or a concern with your company is a stakeholder. As part of being a stakeholder in your organization, it's important to understand the policies and procedures within the organization. Let's first define the difference between a policy and a procedure. A policy is the course of action or guideline to be followed when something occurs. A procedure, on the other hand, outlines the process on how to implement the policy. A policy document or an organizational policy document may look something like this. The policy statement may state the objective of this policy is to provide a framework for conducting industrial relations in the workplace, promote a fair and just working environment, prevent discrimination in the workplace, encourage productivity and efficiency, and provide a healthy working environment. So this we're looking at an industrial relations policy. And then the application of the policy would be to achieve this policy, the following have been implemented: conditions of employment, training policy, grievance procedures, and disciplinary procedures. In this case, we have covered basic conditions of the Employment Act to adopt a policy of fair industrial relations in the workplace according to the Act by providing policies and procedures to govern the conditions of employment, training policies, grievance procedures, and disciplinary procedures. The primary purpose of grievance and disciplinary procedures is to correct behavior and not to punish. It maintains proper conduct and work performance and ensures orderly processes. It's used to ensure that there's a fair opportunity to defend, alike transgressions are treated the same, and there's a certainty of the type of treatment. Reasons for grievance and disciplinary procedures may include incapacitation, when somebody can't really work anymore, when they're too stressed out, when they're late constantly every day, go home early every day, when there's misconduct, behaving against the standards of the organization, and then also bullying and violating people's privacy, and also harassment, including sexual harassment. Now, these are all reasons for dismissal. Now, dependent on what the case is, it could either be a grievance that you have against somebody for bullying, or it could be a disciplinary procedure against somebody that's continually late or that conducts themselves against the policies and procedures of the organization. In the case where somebody is dismissed for misconduct, the following must be considered. The moral of the obligation is to make fair decisions, and this is called substantive fairness. The decision maker must consider that the employee broke a rule of conduct, the rule was valid and reasonable, the employee knew the rule, the employer applied the rule, and dismissal is the appropriate step to take. Examples of serious misconduct include gross dishonesty, deliberate damage, deliberate endangering of safety of others, physical assault, and gross insubordination. So what is it to be fair? Treating people equally without favoritism or discrimination. To ensure fairness, procedure must be followed and requires an employer to conduct an investigation. Procedural fairness requires fair notice, impartiality, gathering of facts, and a fair hearing. Once a grievance and/or a disciplinary procedure or hearing has been conducted or has been sustained in this case or introduced, the employee can be suspended pending a hearing with or without pay, depending on the nature of the case. Only in cases where there is a threat to evidence being tampered with, other employees are in danger, etc., then the employee will be suspended either with pay or without pay, which will also be decided on depending on a variety of factors. The hearing procedure for a grievance or disciplinary action is as follows. There's an introduction, the charge is laid, presenting the evidence, then the findings, mitigating and aggravating circumstances, the penalty is given, and then there's a chance to appeal. In the case of a grievance process, the following applies. If you're dissatisfied, somebody is bullying you, sexual harassment, anything like that, you lay a verbal complaint. The plaintiff is informed in writing. The complaint is submitted, it's investigated, and an outcome given. When we take a look at employment contracts, these are concerning employment-related agreements. It creates a sense of formality, it's formalized, and it outlines the duties and responsibilities of the employee. The Labour Relations Act provides for the following types of agreements. Collective agreements, which is a written contract between employer and unions that outlines terms and conditions of employment for employees in the bargaining unit. Negotiative agreements are agreements between two or more parties seeking to discover a common ground and reach an agreement. Bargaining council agreements are collective agreements and other types of agreements made between an employer and bargaining council for the employee. We get two types of employment contracts, centralized and decentralized. Centralized agreements are those that are negotiated between trade unions and employers and usually include government and tribunals, for instance. They usually entered into on behalf of the employee. Decentralized ones, on the other hand, are entered into between the employer and the employee. Some of this type of agreement are parts of the conditions of employment. They must be drawn up in line with legislation. In this case, the Basic Conditions of Employment Act. Decentralized is the generalized contracts that are used in business today. Condition of employment contracts should include the following elements: the position that you will be holding, your specific job description in terms of all the tasks that you need to be executing throughout your work day, your salary that you will earn at the end of the month, your hours of work, annual leave, sick leave, public holidays, and other basic conditions of employment requirements. And that's a final wrap for Cluster 3. Let's take a look at what we learned in this topic. Stakeholders are anyone that holds a concern in or with an organization. Policies are guidelines to be followed in an organization. Procedures are the course of action taken to ensure the policy is implemented. Grievance and disciplinary procedures are there to ensure fair conduct of non-conformances in the workplace. Agreements are entered into between bargaining councils and the employer. Employment contracts are usually decentralized type contracts, and the employment contract must at a minimum state your position, salary, hours of work, annual leave, sick and public holidays.